seated.
Good afternoon, everyone. You all look like you had a very large lunch. Maybe we'll get livelier, but don't hold your breath on that. Okay, we'll hear the cases as they are listed in order. And any announcements or anything? If not, all right. Would you call the first case, please?
Gonzales versus Orion Federal Credit Union, Financial Federal Bank, and Financial Fedcorp Incorporated.
There's nothing like statutory interpretation to enliven a crowd.
Yes, if there's anybody that's drowsy, this may be a bad afternoon for them. Good afternoon. May it please the court. My name is Timothy Simons. I'm an attorney with the Tennessee Attorney General's office, and our office represents Greg Gonzales in his capacity as Commissioner of the Tennessee Department of Financial Institutions. And I would like to, if I might, I'd like to reserve 5 minutes for rebuttal, please.
Okay, 5 minutes.
And as the court is aware, this is a consolidated appeal that includes two appeals. One, the Commissioner's Rule 3 appeal of the summary judgment order that was entered by the Chancery Court of Davidson County that was against him and in favor of the appellees in the case. And then we also have a Rule 10 extraordinary appeal raised by the Commissioner appealing the Chancery Court's discovery ruling on April 4, 2022, where she found that there was an implied waiver of the attorney-client privilege with respect to certain documents, privileged documents pertaining to the statute at issue in this case, which is Tennessee Code Annotated 45-2-107. And with regard to the Rule 3 appeal, may it please the court, the main issue before this court is the statutory construction of 45-2-107 and whether that statute prohibits the proposed transaction between the appellees, which is at issue in this case. And as outlined in the parties' briefs, the actual issues raised on appeal are as follows. One, whether Tennessee Code Annotated 45-2-107, which restricts acquisitions of Tennessee state chartered banks, prohibits Orion Federal Credit Union their proposed purchase of substantially all of the assets and the assumption of all the liabilities of Financial Federal Bank, which is another one of the appellees in the case. And then our second issue that we have is whether the Chancery Court erred in finding the applied waiver of the attorney-client privilege with regard to documents, privileged documents involving the interpretation of the statute. And in the briefing of Orion, they've raised a supplemental issue that I would also address today, which is as an alternative holding, if in fact the proposed transaction at hand is not prohibited, is prohibited by the statute, should the statute be the transaction be allowed to go forward because of the adoption of federal law preemption, which would preempt the statute from prohibiting this transaction. And that was raised in the briefing, and we'll address that as well. And for the reasons set forth in the briefs, as well as the oral argument today, we're requesting that the summary judgment ruling of the Chancellor be reversed, and because this was decided on cross motions for summary judgment, that the summary judgment be granted in favor of the Commissioner on those claims. We also ask for a reversal of the April 4, 2022 order, which found the waiver of the attorney-client privilege. So those are the issues, and I'd like to go into a little bit about the factual background. As I mentioned, there are three defendants in the case: Orion Federal Credit Union, Financial Federal Bank, and Financial Fedcorp. Orion is a federally chartered credit union, not organized under Tennessee law, but they're organized under Title 12, Chapter 14 of the United States Code. And they have a principal place of business in Shelby County. Financial Federal Bank is a Tennessee state chartered bank located also in Shelby County. And Financial Federal is a wholly owned subsidiary of Financial Fedcorp. Financial Fedcorp is the bank holding company. And at all times relevant to this litigation, Financial Federal held approximately $526 million in deposits in the state of Tennessee. And as far as the authority of the commissioner with regard to the application of this statute, pursuant to Tennessee Code annotated 45-1-104, the commissioner and the department are charged with the execution of all laws relative to persons doing or engaged in a banking or other business as provided in Title 45. And this statute is in Title 45, dealing with regulation of financial institutions, including state chartered banks.
Counsel, let me ask you this question. As often is the case with statutory interpretation case, all sorts of interpretive canons are being thrown back and forth here. But the one that does not get mentioned here, although I guess impliedly so in Orion's brief, is the interpretive direction canon. Because in the subsection that we are interpreting, or you're asking us to interpret in a certain way, there's a definitional section. And normally that's preclusive. Now I notice here that the definitional section says, unless the context otherwise requires. Are you making an argument here that the context somehow means we give a different definition of bank than what the statute provides?
Your Honor, no. I mean, the issue that we have relates to, we're fine with the definition of bank that is afforded the statute.
So we should use that definition?
Yes. The subject of the dispute here relates to this issue of acquire. And as you note from the statute, acquire is not defined. And so that's a lot of the issues that have come up relate to the fact, trying to figure out what the plain and ordinary meaning of the term acquire is as envisioned by the legislature in enacting this statute. But the statute, you're right, the term bank is defined and it is defined as a company that holds deposits in the state of Tennessee. And company is also defined generally under a federal statute, as you're aware, that includes a wide variety of different entities, including corporations.
I mean, so why doesn't that end up an affirmance of the lower court's decision in this case if we're wedded to the definition of bank as used in subsection A?
Well, Your Honor, I think that the definition of bank being a company, I don't think that will undermine the commissioner's interpretation of what acquire means. As we've said, where the main issue is how do you acquire a bank? And as we've discussed before in the briefs, the issue of acquire is not a term of art, and it's more of a general term, and it can include a wide variety of different transactions. Plus, Your Honor, and this is an important thing to keep in mind when you're looking at what does acquire mean in the context of a bank as defined in the statute. By including that very general definition that includes all different kinds of entities, I think that supports the argument that acquire needs to be viewed more broadly, because as we know, if a bank is not only a corporation, but it can be an LLC or something else as envisioned by the statute, the overly regimented argument that they raise, the other side raises, that it has to be a sale of stock, purchase of stock, or the charter, dissolves because you have potentially other types of entities that can be a bank. And we think that...
So what kind of entity can be a bank in the state of Tennessee that falls outside of what I would call a company? Can a person be a bank?
Well, I think... I know that we cite a statute that talks about how an LLC can be a bank.
Well, that's a company. Yeah.
Well, it's
a limited liability company.
But it's a company, but it doesn't have, a a corporate structure in the sense that it doesn't issue common shares or whatever. It has membership interests.
Well, is there any type of entity other than a corporation or an LLC that can be a bank under Tennessee law? A state chartered bank, I should say.
I do not believe, based on my reading of the statutes, those are the two that are specifically mentioned.
Yeah, I mean, you couldn't have a partnership or a limited partnership be a bank under Tennessee law for certain.
I agree, but also, Your Honor, keep in mind that whether the statutes, whether there are other types of entities that can be banks, although the current statutes mention corporations and LLCs, the mere fact that it's defined, a bank defined more broadly, I think supports the commissioner's argument that the legislature intended for a more broader view of what an acquisition would be because of the fact that it encompasses a wide variety of entities or businesses. Like, for instance, the federal statute that defines company, it includes the term association. It includes a lot of different things that aren't incorporated that, that could be a partnership. Those things in the legal analysis, an association doesn't necessarily have to be in a company. That could be just 2 or 3 people working together.
So, I'm sorry.
No, go.
I was just,
Sorry.
so under that logic then, you're saying that we should ignore under the definition section the word company, and we can insert in there association, for instance.
Well, what I'm saying, Your Honor, is that the word company adopts the federal definition, and that federal expressly adopts it, and that federal definition is a very broad definition of company that includes things such as associations. That's my point, Your Honor, which is, so I think you guys, when the legislature was enacting this back in, many decades ago, by them adopting that, I think evidence is an intent that they wanted to view this term acquire as being much broader than the very strict way that the chancellor looked at it. So that's Your Honor, I hope that answered your question. But let me get into the court.
You've used up your time, haven't you?
Oh, I'm up already?
Red light goes on,
Well,
time's up.
So I guess I'll address the rest of it in 5 minutes on rebuttal, right? Thank you, Your Honor. Appreciate it.
Time passes so
Yes,
quickly.
it does, Your Honor, it does. Good afternoon. I'm Bridget Carpenter, and I'm here representing 2 of the Appellees, Financial Federal Bank and Financial Fedcorp, Inc. Mr. Sims and I, Mr. Sims represents Orion, have agreed to try to divide up our time. I'm going to try to take approximately 10 minutes. I'm looking at my watch here, and hopefully I can do so, and I'm going to try to address statutory construction, plain language of the statute, in 45-2609. Mr. Sims will address, in the time he's got, some other issues, including deference, if you have any questions about that.
Okay, 10 minutes for you, 5 minutes for him.
Correct.
Okay.
Thank you. I wanted to go back to the issue that you just raised about company, because here it doesn't really, while I understand that the statute borrows the definition of company from the federal statute, and it does include association, trust, so forth, in Tennessee, a bank must be a corporation or an LLC. And so for purposes of acquire under 45-2-107, the argument, I think, is just not applicable. The argument they're trying to make that, hey, look.
That would be where the context requires otherwise.
That's
then.
right.
Yeah. So,
That's right.
And that's what limits all that.
That's right. So, Your Honors, I wanted to address that, but I want to go back and start here with a statute that we believe is directly on point.
Now, let me ask something just to be certain I understand. The Orion is not purchasing the name or goodwill or anything like that of FFB, correct?
That's right.
So when this purchase, assuming this purchase is completed, FFB will still be there. It just won't have anything, and they are going to dissolve. essentially.
They will make application to dissolve and terminate. That is absolutely correct.
So your position would be, does that jive into your position of this is not acquiring a bank?
It does. It absolutely informs that, because the Appellee's construction is that the plain language of 45-107 and the meaning of acquire does not include, as the Chancellor held, the purchase of all or substantially all of the assets. And that is first and foremost because look at what acquire means. It's not defined. So both sides went to Black's Law Dictionary. Gain ownership of, get as one's own, or come to have. Orion is going to own assets, but it is not going to own stock. We know that the bank stock is not being purchased. The charter is not being purchased or transferred. We know that when the deal is done, as you just mentioned, there will still be a corporation that must be dissolved and terminated. If Orion were acquiring the bank as an entity, none of that would be the case. And I would submit that if Orion were acquiring the bank as an entity, then the resulting entity of this purchase transaction would be a bank. But it is not going to be a bank. It's going to be a federal credit union that happened to have purchased the assets of this Tennessee State Chartered Bank. This is straightforward. And I think there's a lot of paper before the Chancellor, before the Chancery Court that's now before this court and a lot of briefing. But I would submit that, just as we argued there, this is a straightforward issue. It's not that difficult under the plain language of 45-107 and 45-609, which I do want to get to because this is significant. 45-609, aptly enough, is titled Sale of Assets, and it's in the Tennessee Banking Act. And it says, a bank may sell any asset in the ordinary course of business, but the sale of all or substantially all of the assets of a bank shall entitle dissenting shareholders to the rights provided by 45-1309. If the General Assembly intended to limit to whom a bank could sell its assets, it would have done so right here in the section titled Sale of Assets. There's no such limitation. The only limitation is to give dissenting shareholders their rights.
Counsel, I'm struggling with the trial court's leaning on the interpretive canon of expressio unius in this case. I just don't see how that's applicable at all here. And we're talking about a interpretive canon that's essentially designed for when you expressly say something, list a series of things, and you don't reference something else, we assume it's excluded. How does that have application to defining acquire in another portion of the chapter, but not here? That seems like a real stretch of that canon, and it seems to have been an important undergirding of the trial court's ruling in this case.
I do think it's important, and I think it was important to the Appellees, and we relied on it as well. And I think we did so because to prop up their definition of acquire, the commissioner is relying upon other statutes that specifically define acquire. They're in Title 45, but they're in different acts. And interesting, first of all, most significantly, I think, those sections or those sections and acts state as used in this part. So we would not. They're limited by their terms to being used in that particular part of Title 45. But secondly, even the definitions of
to a contrary definition elsewhere in terms of. I'm still struggling to see how this interpretive canon suggests, because the legislature defined acquire in another portion of this part, but not in this act, that we should read it as a presumption that the definition is different, rather than really the legislature just hasn't spoken to what the definition is in that particular act.
But I think we would submit that canon, which has been reiterated twice in 2020 by the Tennessee Supreme Court, the two cases we cited, the Effler case, and I think it's State versus Welch, That,
Incredibly well-established canon. It's a strange context to use it in, at least as I see it.
but if to me, it is directly applicable because the Tennessee General Assembly chose to define acquire in a certain way that included the purchase of all or substantially all of the assets in portions of Title 45. It did not choose to do so over here in the Tennessee Banking Act. And therefore, based on that canon, which I believe is directly applicable, it should mean something different. But, Your Honor, if the reason that we, and I think the court below relied on that, is because the commissioner is trying to use those to prop up his definition. So if we want to throw out those canons, because the seminal rule of statutory construction is you look at if it's unambiguous, you look at the plain and ordinary meaning. So if we want to do that, that's our first argument. And there, you don't have to get to these other canons because acquire here cannot mean what the commissioner says it means. And that's because at the end of the day, after this purchase transaction is closed, there's still stock that's owned in Financial Federal Bank. There's still a charter and so forth. So I guess that's a long way of getting around to, you don't need to go there to rule in favor of the appellees and to affirm the Chancery Court, because the first canon of statutory construction, that you apply the plain and ordinary meaning, is sufficient. And hopefully that answers your question. Let's see. Okay, I'm good. I know I keep doing this. I'm going to go back to 609 one more time in my remaining time. Again, and I do this because we think it is significant. The commissioner gave very short shrift to this in all the briefing and the argument below. But again, if the General Assembly wanted to limit who an asset sale, this is about an asset sale. It is directly applicable to the purchase transaction that is the subject of this case. And that's where you should start. You start with a statute that applies to what is going on in this transaction. There's no limitation other than the dissenting shareholders' rights, and we think that is very instructive. And that is the authority by which Orion may purchase substantially all of the assets of Financial Federal Bank. So, again,
You haven't been going with 45-2107 at all. You started out under 45-2609.
well, but I think in response to the comments about statutory construction, our argument on 45-2107 is that it does not, we've got the statute over here, 609, that allows it. 45-2107 does not take that away. And that's because the plain and ordinary meaning of the word acquire in this instance, where there is a corporation that will remain, does not meet that definition.
I get that. I was just trying to, in a nice way, ask who brought up 45-2107 into this in the first place. Did the state bring it up, or did you? And if you did, why?
45-2107?
Yes.
That is the statute upon which the commissioner sued. That is the entire basis, ground for the commissioner bringing this suit.
Gotcha.
So I've got
Your
11
time's
minutes.
up.
I'm going to defer.
Red
to
light's out.
Mr.
Time's up.
Thank you very much.
You're welcome.
Good afternoon, Your Honor. Scott Sims on behalf of Orion Federal Credit Union. I don't think I've ever been able to say anything in 5 minutes, but I'm going to try.
That's all you got.
Well, I know. I'm going to talk fast. I've also been accused of being a fast talker, so here goes. I want to make 3 additional points about interpretation. The first has to do with deference. The commissioner's interpretation is not entitled to any deference. That's given to an agency's interpretation of its own rules for good reason, but not to its statutory interpretation. It's crystal clear that is an issue to be reviewed de novo, and the Pickard case tells us that. Second, I think it's helpful to step back a bit and look at the purposes of the Banking Act. The commissioner himself testified that the purpose of the Banking Act was to secure a safe and sound banking system. If you look at this transaction, it's unquestionably safe and sound. Orion's large and financially stable. Orion is closely regulated by the National Credit Union Administration, or the NCUA. The transaction has to be approved by two governmental entities, the NCUA and the FDIC, and the transaction is good for everyone that's involved. There are no negatives, and the commissioner in his deposition could not identify any negatives. Nevertheless, he rejected this transaction out of hand without even looking at the safety and soundness, and we think that speaks volumes about the reasonableness of his interpretation. Third, the commissioner's interpretation is contrary to his prior approval of similar transactions. So if you look at A3 of 45-2-107, it says only bank holding companies can acquire banks. Now, if that includes buying substantially all of the assets, that creates two large problems. Number one, bank holding companies by definition hold banks. They don't buy assets, they buy entities, okay? Number two, the commissioner has allowed non-bank holding companies to acquire all the assets of state banks. Now he says, well, that's permitted by A2 because A2 references banking institutions, and these acquiring banks were banking institutions. The problem is that violates the clear language of A3. A3 says if you're not a bank holding company, you cannot buy a bank. More importantly, it makes A3 superfluous, because if you're the acquirer and you're not a bank holding company or a bank institution, you fail under A2, okay? You never get to A3. On the other hand, if you are a banking institution, you're good under A2, but you fail under A3. But the commissioner conveniently says, well, you know, you don't get to A3. We just disregard A3. But the point, and that's how I was able to approve these prior transactions. But the point is, either way, A3 is superfluous. I mean, the words on the page are worthless, and that flatly contradicts the rules of statutory construction. Lastly, preemption. We submit that an alternative ground to uphold the trial court, and you don't have to go here if you affirm the main ruling by the trial court, but if this law blocks this transaction, it would be preempted by federal law. It's conflict preemption. It's a state law blocking accomplishment and execution of the full purposes and objectives of federal law. It's exactly what we have here. The Federal Credit Union Act, the FCUA, empowers credit unions to purchase all of a bank's assets for the purpose of promoting credit and thrift or savings for Americans, and especially to avoid banking deserts. And in fact, the NCUA and the FDIC have approved more than 40 of these types of transactions. So if 107A blocks this transaction, it would thwart the purpose of the FCUA, and the result would be preemption.
Counsel, when you reference this as a form of conflict preemption, which subcategory of conflict preemption would you put this in? Is this obstacle or is this impossibility?
It's obstacle.
Okay.
Is there any way to read A2 and 3 and give both effect?
If there is, I haven't found it in a year and a half.
All right, that's probably a question. That's probably a question for the state then.
Thank you.
Thank you.
30 seconds early.
Yeah, so we say you do not have to use up all your time.
We've clearly caught the presiding judge in a mood this afternoon.
I will be a little more judicious in my time this time. The issue 45-2609, as we pointed out in the brief, it says what it says.
And it would seem that would be a really excellent place to say, but you need to also comply with 107.
That's correct.
Yeah.
Basically, it's silent. It's from the seller's perspective.
Yeah.
It's not from the buyer's perspective. So, you know, the fact that you have two statutes, one that says you can sell an asset, but you have another statute that regulates who the buyer can be of a banking institution, certainly makes sense, because banks need to be regulated as part of the Department of Financial Institutions. It's a very crucial institution. So to somehow say that those are inconsistent, we don't believe is valid. So we think 45-107 speaks to who can purchase such assets. The other thing I was going to mention, to address your question about acquiring a company. In our reply brief, we cited some general authority. Granted, it's persuasive authority, it's not Tennessee authority, but that stands for the proposition that acquire a company, acquire is not a term of art, and therefore it can include, the acquisition of a corporation can take many forms, including, because of that general definition of acquire, it doesn't have to be the traditional just purchasing the stock, that it can also be viewed, depending on the circumstances, as the acquiring of all the assets. Or
Well,
substantially
yeah,
all.
I understand and appreciate that, but it seems like to me that the statute then should have been written, if you're going to use a definition for the term bank, acquire a bank or substantially all of the bank's assets.
Well, all I can say that, Your Honor, is obviously the statute is not clear on that. And so
So what's the state's position on how you read A2 and 3?
Okay, but I would say it's not clear, but I think if you take it in the context of the other provisions and the other provisions of 45, it does become clear as to what the meaning was. Okay. But with respect to the analysis that the commissioner has proposed consistently through the Chancery Court action and in our briefing before this court has been, you take this statute as it comes, you take it section by section, and A2 and A3 are different tests that you look at to decide whether a proposed transaction, if in fact it is an acquisition, whether it's permissible under the statute. So you look at A2, which deals with the, and I have it here, Your Honor, A2 talks about no bank holding company or other banking institution shall acquire, form, or control a bank unless certain conditions are met. And it says the bank must accept deposits in Tennessee and engage in the business of making commercial loans in Tennessee. So the first stand is looking at that to see if a banking institution is defined as being a state chartered bank, a federal bank, or any other institution that's formed under Title 45. So you go through that and see if you check all the boxes, and if the bank that's being acquired, or the assets being acquired, do that check all the boxes? If that's okay, I think that's the end of the discussion, because you have a statutory provision that allows that transaction to go forward. The commissioner says that that A3 is then implicated if you don't meet the requirements of A2. You go to A3 that talks about just generally a bank holding company that is not a bank holding shall acquire, form, or control a bank. We think that's the way you harmonize these two things. And also, I'll point out, Your Honor, with regard to A2 and A3, if you notice, the bank that can be acquired under A2 has conditions attached. A3 doesn't have that same limitation. So I think there is a distinction there. It's not talking about synonymous circumstances. But what we do, Your Honor, and what the commissioner did is go through A2 and A3, and with respect to analyzing it, Orion Federal Credit Union is a federally chartered credit union, therefore is not a banking institution, is not a bank holding company, which has been stipulated that they're not, and they can't own stock of a corporation. So they don't. Now, the Financial Federal meets the requirements under B2 of a bank that makes loans and has deposits, but because Orion is not an approved entity under B2 and is not a bank holding company under A3, then they cannot acquire the bank. So I would just ask the court to reverse the ruling of the chancellor. Thank you very much.
Thank you. Thanks to all of you. Giving us some fascinating things to think about.